We do have Surbi, who's joining in for additional information at what she's picking up. She's been working the phones with regards to the FPI disclosure regulations background and what might be worrying FPIs at this point. Surbi.
Ekta, thanks very much for that. Indeed, Nimesh also always picks up all the chatter from the dealing rooms, but today on this issue, there is chatter in legal circles and the legal offices as well. Now, just to dial back a little bit and give our viewers some context, if you remember, there was some volatility in the market towards the end of January this year itself. Why did that happen? Because this August 23 circular, which is being spoken about, that came into effect on the 1st of November. And those who were breaching the criteria, like Nimesh just pointed out, this 25,000 crores of AUM or exposure, a very large exposure in any single corporate entity, those who were in breach were given a 90-day window to either disclose all the details of the beneficial owners or lower their stake, pare down their stake so that they don't meet the trigger threshold. Now, those who did not disclose by the end of January were given an additional grace period, an additional 30 days of, grace period to disclose, basically, by March. And those who were still non-compliant, FPIs who were still non-compliant, they were told that they have to wind down their businesses in India, they have to hand over their FPI license, and then exit in the next 180 days. And that 180-day deadline is finally drawing to a close. Now, what's the side story to this? Why has it become such an issue? Because 180 days is a fairly long period of time, and this is nothing that we're discussing is new. What happened on the side was that there was an exemption list or an exemption criteria that SEBI had originally pointed out, which would allow relief to a large section of the FPIs. What was the original exemption idea? To put it in a nutshell, it said that if you are a diversified pooled investment vehicle and if you're regulated by your home jurisdiction market, then, in all probability, you would be exempt from the purview of this August 23 circular. So a lot of FPIs thought that they will get the exemption. But then that's where the plot really thickens, because earlier this year, there were tweaks to the exemption criteria. There was a communication from SEBI to custodians that was put out. Then there was something in public domain, a formal change of the criteria in May that took place. But in the interim, what happened was a lot of back and forth between FPIs and the regulator. While the limbo was continuing, the deadline is now upon our heads. So that's the backstory to it. The question is, what happens from here? We have with us Mr. Shikhar Kicker, counsel at Khaitan & Co. Shikhar, great to have you on. Thanks so much for joining. And this is an important matter. But tell us, a lot of these FPIs who had appealed to the regulator saying that they should be exempt from the purview of the circular, are they a lot in number? Are we talking about large sums of money here? How should we assess the actual impact?
If you look at the actual impact, there is a fair bit of FPIs who otherwise, when the actual circular came into effect, were not impacted. But the way the situation progressed, as was mentioned, as was briefly covered by you as well, over a period of time when the actual deadline came in, so all the FPIs were given a 90-day period within which they could pare down their holdings starting from 1st of November. And after those 90-day period, they had a 30-day window to bring down their holding. Now, most of the FPIs, which are structured as regulated investment pools, they were under a genuine belief that they would be eligible for these exemptions. So when, after the expiry of the 90-day period, when they reached out to SEBI, asked with the local custodian, telling them that we are not subject to this 30-day grace period and our exemption should be taken on record. At that point in time, because the number of FPIs was such that almost every single FPI that SEBI was tracking was seemingly eligible for this exemption. So SEBI internally communicated to DDPs that put these applications on hold. And now this is where the challenge began, because you've changed the rules of the game once the game has actually started. So the date on which these DDPs, when these FPIs reached out to the DDP local custodian telling them that we are exempt, they were under a genuine belief that they are eligible for this exemption. But their applications were put on hold, B, the deadline was not extended. So in the meantime, in absence of any legal solution to the problem, all the FPIs were advised by the custodians to reach out to SEBI by making a formal application under the residuary powers of SEBI under Regulation 43B to seek an exemption. Now, that's a residuary provision, general powers given to SEBI to grant exemption to FPIs from strict compliance of the regulations. But there is no statutory timeline provided for SEBI to decide those applications. And this is where the problem is, because most of these FPIs, their applications are pending. Now, at the end of the, yes, there are still a host of applications which are pending. Now, the problem is that at the end of the timeline, one, they are aggrieved that the rules of the game have been changed after the game has begun. The second problem is that there is no response from SEBI. So there are several FPIs who've reached out to SAT, moved a petition asking for directions for expeditious disposal of their applications. And now, after the SAT has issued notice, SEBI has started disposing those petitions now. So now this is where the entire problem is, that there is...
Got it, Shikhar. I think you've explained it really well, that while the whole exemption process has gone into limbo and these applications are pending with SEBI and the matter has gone even to SAT, as you say, the timer on the other side has still been ticking. The countdown to that 180-day deadline, that has still been on. So at a more broad level, to understand if there is any precedent in other matters, supposedly, when there is a dispute between the FPI concerned and maybe the regulator on any regulation, can it be taken as a given that while that dispute will be resolved, the outstanding deadline needs to be frozen as well? I mean, was that the premise with which the FPIs were working with? Because I think the street is also surprised why this was not accelerated, considering the deadline is today.
That's true. So in fact, I would not say that this is a dispute. A dispute will arise only if you bring in a formal amendment to the regulation. When you came out with your August circular, it was followed by a standard operating procedure which all the custodians were supposed to adopt. The process written down in that standard operating procedure was never amended until end of May. So while in Feb there was an oral communication, and only towards the end of May you are making an amendment to the standard operating procedure, and that cannot be said to be a legal dispute or an interpretation dispute. This is a right which has already accrued to me the day on which I am moving to the custodian with a request for an exemption.
Shikhar, of course, you deal with a lot of clients, on the FPI side, and maybe I know you can't sort of share details, but perhaps some of them would be aggrieved parties as well. What has been the general chatter and the thought process? Are FPIs willing to comply till this gets resolved at either SEBI or SAT level? Has there been chatter about paring down holdings or disclosing? I mean, the option is either you pare down holdings or you disclose. What is the thought process within the FPI community and the clients that you interact with?
SEBI has offered a fait accompli to the FPIs that you either disclose or your license will be rendered invalid. So most of the FPIs, their licenses have been already rendered invalid. Now they are sitting with that hope that till the time if their 43B application is looked at favorably, then at least the license which has been rendered invalid can be reinstated. Now, having said that, this also leads to a larger debate on the need for such a circular and the purpose by which this has been taken out, because seemingly the FPI regulations were revamped in 2019 when they adopted the same disclosure threshold which has been given by the Government of India in the PMLA rules, which is you have to disclose beneficial owners at 10% and more of the FPI level. Now, in the backdrop of this Hindenburg report, while SEBI has got protocols to invoke and it can ask the information of all the beneficial owners from its counterpart regulators, but to invoke those protocols, SEBI has to establish a prima facie case of money laundering or some form of wrongdoing. Now, in absence of any investigation in India, which SEBI has initiated, SEBI is finding it difficult to get this 10%, the below 10% details from its counterparts. And this is where this is the issue which SEBI is trying to address, while the Government of India policy has not changed. Now, this is where FPIs have a problem, because when they're entering the market, they want a stable Government of India policy, which is the 10% threshold. Now, changing the rules of the game, asking for an additional layer of disclosure without any actual evidence of wrongdoing is what is creating a fiction. And secondly, we have to also understand the nature of investors who are there, who come into these FPI. These are not strategic investors. These are portfolio investors, retail investors who have pooled in money through various private banks, omnibus accounts, or feeder vehicles. Now, asking for details at a granular level becomes difficult even for the FPI, because FPI also do not have actual control over these investors. These investors are actually clients of an omnibus account or a private bank which is invested into the FPI.
Okay, so finally, to sum things up, Shikhar, now whoever isn't winding up by today or by Monday, that FPI will have to pay an additional penalty, right? So just, tell us exactly what that penalty is going to be levied on this 5%. How will it be calculated? And what you expect from here on? How do you expect the matter to proceed? Do you expect sort of a collective sort of a suit at the or intervention sought at the SAT level? Do you expect maybe SEBI to come out with some fresh, if not relaxations, or maybe clarifications on this? What do you expect ahead?
No, definitely, there has to be a collective debate on this topic, and this rules actually need to be relooked. As things stand today, anyone who's not been able to wind up their position will have a 180-day period during which they will have to either wind down their position or the securities will be written off thereafter. Whatever sales they do, out of the sale proceed, 5% will be remitted to the Investor Protection Fund. Now, until and unless the pending 43B applications are favorably looked at by SEBI. So I think SEBI should actually look at those 43B. So while the law itself needs to be reconsidered, whether this law is actually required and to what extent are we going to not allow private pooled investment vehicles from this exemption. But those who have actually moved in an application, their application should be looked at favorably, because that otherwise would mean winding down the entire structure, because your license will be rendered invalid, the structure would be wound down, and the investors in these FPIs will have to be redeemed. Now that is a huge cost, and once you've actually wind down the position, the likelihood of whether the FPI wanting to set back a new structure or even reinvesting the money which it has exited from the India market back into the India, it raises a question mark and actually a bitter taste. So while there may be good, genuine commercial, economic reasons to come back, but given the regulatory and the friction that has been created right now, they may not want to bring back that capital back into India.
Fair point, and strong arguments on both sides. The regulator batting for absolute transparency and granular disclosure, and FPI saying that if you were supposed to be exempt earlier, then if the criteria has been changed, then why not now? So I think we've not heard the last on this matter, but thank you very much for putting it in context. With that, let me hand it back to Nigel. So Nigel, this is maybe causing a little bit of the volatility that we're seeing in the market today. Matter is not over. I think FPIs are still hoping for some clarification, if not relief.
Got it. Thanks a lot for